The morning sun cast long shadows across the marble steps of the Henrico County Courthouse, its rays struggling to penetrate the thick windows of courtroom 4B. Inside, the air hung heavy with the weight of routine proceedings and worn expectations. Judge Robert Whitmore adjusted his black robes as he settled into his high-backed chair, his weathered face bearing the expression of a man who had seen it all. At 62, he had presided over thousands of cases, and today promised to be no different from any other mundane Tuesday morning. The docket was filled with the usual suspects' traffic violations, minor infractions, and petty disputes that formed the backbone of municipal court business. Whitmore's eyes scanned the list with practiced indifference, his gaze lingering momentarily on a name that stood out among the rest, Javon Washington versus the City of Richmond, represented by prosecutor Helen Fisher. The courtroom was sparsely populated save for a handful of spectators, court staff, and the usual rotation of lawyers shuffling papers and whispering among themselves. The morning light filtered through the tall windows, casting geometric patterns across the polished wooden benches where citizens waited their turn before the bench. Javon Washington sat in the third row, his posture straight and alert despite the early hour. At 17, he possessed a quiet intensity that seemed almost out of place in the drowsy atmosphere of the courtroom. His dark eyes moved methodically across the room, taking in every detail with the precision of someone accustomed to observation and analysis. He wore a simple but well-pressed button-down shirt and slacks, his appearance respectful but unremarkable to the casual observer. Judge Whitmore called the court to session, his gavel echoing through the chamber with authority. The familiar ritual began, with Clerk Nancy Palmer reading case numbers and defendants stepping forward to address their charges. Traffic violations were dispatched with efficiency, fines assessed with mechanical precision, and warnings issued with the weariness of countless repetitions. The morning progressed with a predictable rhythm until Palmer's voice carried across the courtroom with clear precision. Case number 2024 CV 7841, Javon Washington versus the City of Richmond, regarding citation for disturbing the peace and unlawful assembly. Javon rose from his seat, his movement fluid and confident as he approached the defendant's table. The prosecutor, Helen Fisher, a sharp-featured woman in her 40s with steel-gray hair pulled back in a tight bun, shuffled through her papers with practiced efficiency. She glanced up as Javon took his position, her expression neutral but assessing. Judge Whitmore looked down from his elevated position, his eyes narrowing slightly as they fell upon the young man standing before him. The sight of yet another young black defendant seemed to trigger something in the judge's demeanor, a subtle shift that experienced court watchers might have recognized but most would have missed. "Mr. Washington," Whitmore began, his voice carrying the weight of judicial authority tinged with something else, something less professional. "I see you're here without representation. Did your family not see fit to hire you a proper lawyer, or are we dealing with another case of misguided self-confidence?" The question hung in the air like smoke from an extinguished flame. Several spectators shifted uncomfortably in their seats, while court reporter Shanice Jenkins's fingers paused momentarily over her stenotype machine. The judge's tone carried an undercurrent of condescension that made the morning air feel suddenly thicker. Javon's expression remained composed, his dark eyes meeting the judge's gaze without flinching. "Your Honor, I am representing myself in this matter. I believe I am adequately prepared to address the charges brought against me." Whitmore's eyebrows rose in apparent amusement, a thin smile playing at the corners of his mouth. The sight of a teenager attempting to navigate the legal system without professional help seemed to strike him as particularly entertaining. He leaned back in his chair, his robes rustling with the movement, and fixed Javon with a look that spoke volumes about his expectations. "Adequately prepared," the judge repeated, his voice dripping with skepticism. "Young man, this isn't a high school debate club or some television drama. This is a court of law, where real consequences await those who don't understand the gravity of their situation. Are you absolutely certain you don't want to request a public defender? I'd hate to see you learn this lesson the hard way. The prosecutor Fisher cleared her throat, preparing to present her case, but Whitmore raised a hand to silence her. His attention remained fixed on Javon, as if the young man's presence had become a source of personal amusement. The courtroom had grown unusually quiet, the typical morning bustle replaced by an uncomfortable tension that seemed to emanate from the bench itself. Furthermore, Whitmore continued, his voice gaining momentum like a train gathering speed, I find it rather presumptuous that someone of your age and, shall we say, background would assume they possess the legal acumen necessary to navigate these proceedings. The law isn't something you learn from watching movies or reading Wikipedia articles, Mr. Washington. Javon's jaw tightened almost imperceptibly, but his composure remained intact. His hands, clasped behind his back, showed no tremor of nervousness or uncertainty. If anything, the judge's condescending remarks seemed to sharpen his focus rather than diminish it. I understand the gravity of these proceedings, Your Honor, Javon replied, his voice steady and clear. I'm prepared to address the charges and present my defense within the proper legal framework. The judge's smile widened, taking on an almost predatory quality. He glanced around the courtroom as if seeking an audience for what he clearly viewed as an entertaining spectacle. Several court staff members avoided his gaze, their discomfort evident in the way they busied themselves with papers and procedures. The proper legal framework, Whitmore echoed mockingly. How refreshing to hear such sophisticated language from someone who, according to these charges, was allegedly disrupting the peace at a community meeting. Tell me, Mr. Washington, did you also learn about constitutional law during your alleged disturbance? The question was designed to belittle, to reduce Javon to a stereotype that would be easier to dismiss and sentence. Whitmore's years on the bench had taught him how to wield his authority like a weapon when he chose to do so, and this morning he seemed particularly inclined toward such displays. Prosecutor Fisher shifted uncomfortably at her table, her eyes darting between the judge and the defendant. While she was prepared to argue her case, the judge's obvious bias was making her increasingly uneasy. She had prosecuted hundreds of cases before Whitmore, but his behavior this morning struck her as unusually hostile. Your Honor, Fisher interjected carefully, perhaps we should proceed with the presentation of evidence and testimony so that justice can be properly served. Whitmore waved her off with barely concealed irritation. His focus remained locked on Javon, as if the young man's mere presence challenged something fundamental about the judge's worldview. The courtroom had become a stage for something more than just legal proceedings. It had become a theater for the playing out of deeper prejudices and assumptions. In just a moment, Counselor Fisher, Whitmore replied without taking his eyes off Javon. I'm still trying to understand what we're dealing with here. Mr. Washington, are you employed, in school, or are we looking at another young man who has decided that society's rules don't apply to him? The questions came like jabs from a boxer testing an opponent's defenses. Each one carried layers of assumption and prejudice wrapped in the veneer of judicial inquiry. Javon stood silently for a moment, his expression unreadable as he processed not just the questions, but the motivations behind them. I am currently a senior at Richmond High School, Your Honor, Javon replied with the same measured tone he had maintained throughout the exchange. I maintain a 4.0 grade point average and am actively involved in several academic organizations. Academic organizations, Whitmore repeated with a snort of derision. How impressive. And I suppose these organizations taught you that you could represent yourself in my courtroom without consequence? That your academic achievements somehow qualify you to practice law? The judge's voice had grown louder, more aggressive, causing several spectators to lean forward in their seats. Bailiff Jerome Thompson, a middle-aged black man who had served the court for over 15 years, watched the proceedings with growing concern. He had seen judges display bias before, but rarely so blatantly and in such a public forum. Javon's response came with the precision of a surgeon's scalpel. "Your Honor, I believe every citizen has the constitutional right to represent themselves in legal proceedings, regardless of age or background. This right is fundamental to our justice system." The statement hung in the air like a challenge thrown down before a king. Whitmore's face flushed slightly, his composure cracking as he realized that this teenager was not going to be as easily intimidated as he had assumed. The courtroom fell into complete silence, the only sound being the soft whir of the air conditioning system. "Don't lecture me about constitutional rights, young man," Whitmore snapped, his judicial demeanor slipping like a mask knocked askew. "I've been practicing law since before you were born. I know what rights you do and don't have in my courtroom." The possessive phrase "my courtroom" revealed more than Whitmore probably intended. It exposed a view of justice as personal domain rather than public service, a perspective that transformed the bench into a throne rather than a seat of impartial judgment. Javon nodded respectfully but did not back down. "Of course, Your Honor, I meant no disrespect. I simply wish to exercise my right to self-representation while following all proper procedures and protocols." Judge Whitmore stared down at the young man for a long moment, his anger warring with his judicial training. The courtroom remained frozen in uncomfortable silence, as if everyone present sensed that something significant was unfolding before them. The morning routine had transformed into something altogether different, something that would resonate far beyond the confines of courtroom 4B. What Judge Whitmore didn't know, what none of the people in that courtroom could have guessed, was that standing before them was not just another teenager trying to navigate the justice system. Javon Washington carried secrets that would soon transform this moment of judicial arrogance into something unprecedented in the courthouse's long history. The stage was set, the players in position, and the drama that was about to unfold would expose truths that no one in that room was prepared to face. 3 years earlier, on a sweltering afternoon in July, 11-year-old Javon Washington sat cross-legged on the worn carpet of the Richmond Public Library's children's section, surrounded by towers of books that seemed to defy the laws of physics. While other kids his age were playing video games or swimming at community pools, Javon was lost in the intricate world of contract law, constitutional precedents, and civil procedure. The transformation had begun innocuously enough. Tamika Washington, a single mother working 2 jobs to keep food on the table and lights burning in their small apartment, had discovered her son's unusual reading habits during a routine bedroom cleaning. Hidden beneath comic books and school assignments, she found volumes on criminal justice, constitutional law, and legal theory books that belonged in a law school library rather than an 11-year-old's bedroom. "Javon, baby," Tamika had said that evening, settling beside him on their second-hand couch, "where did you get these books? And more importantly, why are you reading them?" Javon had looked up from a particularly dense passage about Fourth Amendment protections, his dark eyes serious beyond his years. "Mama, remember when Mr. Henderson got evicted last month? He kept saying the landlord didn't follow proper procedure, but nobody believed him." I wanted to understand what proper procedure actually meant. The conversation that followed revealed the depth of her son's curiosity and the systematic way he approached learning. Javon explained how he had started with simple legal questions sparked by neighborhood incidents, then found himself drawn deeper into the complexities of the law. Each answer led to 10 more questions. Each concept opened doors to entire fields of legal knowledge. Tamika Washington was not an educated woman in the traditional sense. She had dropped out of high school when Javon was born, choosing to work rather than pursue her diploma. But she possessed something perhaps more valuable, the wisdom to recognize exceptional talent when she saw it, even if she couldn't fully understand its implications. "You understand all this?" she had asked, flipping through pages of legal jargon that might as well have been written in ancient Greek. Javon nodded with the confident simplicity of childhood genius. Most of it. The parts I don't understand, I look up. Then I look up the things I need to look up to understand those things. It's like building with blocks, except the blocks are ideas. That night, Tamika Washington made a decision that would change both their lives forever. She would find a way to nurture her son's gift, regardless of the obstacles that stood in their way. The path would not be easy for a working-class black woman in Richmond, but she had something that money couldn't buy: absolute faith in her child's potential. The first step came through an unexpected source. Mrs. Eleanor Hartley, the head librarian at Richmond Public Library, had noticed the young boy who spent entire days buried in legal texts. Initially concerned that he might be struggling with some family legal issue, she approached him with gentle questions about his reading choices. "Are you helping your family with something, sweetheart?" Mrs. Hartley had asked one afternoon, sitting beside Javon in the legal reference section. "No, ma'am," Javon replied politely. "I just find it interesting how everything connects. Laws aren't just rules, they're like the foundation that holds everything else together. When I understand the law, I understand why things happen the way they do." Mrs. Hartley, a former paralegal herself, recognized something extraordinary in the boy's explanation. That evening, she made a phone call that would prove pivotal to Javon's future. Antoine Dubois, a prominent civil rights attorney with offices in downtown Richmond, initially dismissed the librarian's enthusiastic description of a gifted child. "Eleanor, I appreciate your concern for the community's children, but I really don't have time to mentor every bright kid who shows an interest in law," Antoine had said, his voice weary from a long day of depositions and court filings. "Antoine Dubois, you listen to me," Mrs. Hartley replied with the authority of someone who had known him since he was checking out picture books. "This isn't just any bright kid. This is someone special. Give me one afternoon. If I'm wrong, I'll never bother you about community outreach again." The meeting took place on a rainy Thursday afternoon in September. Antoine Dubois, a tall man in his 40s with graying temples and the bearing of someone accustomed to courtroom battles, arrived at the library with the resigned patience of someone fulfilling an obligation to an old friend. What he found challenged every assumption he had made about the meeting. Javon Washington, barely 12 years old and dressed in his best school clothes, sat across from him at a conference table in the library's study room. Between them lay a stack of legal briefs, case summaries, and constitutional analysis that Javon had prepared specifically for their discussion. "Mr. Dubois," Javon began with formal politeness, "I've been following your cases in the local papers. Your work on the Henderson versus City of Richmond housing discrimination case was particularly interesting. I noticed you cited Brown versus Board in your constitutional arguments, but I wondered why you didn't also reference Jones versus Mayer, which seems directly applicable to housing discrimination issues." Antoine's eyebrows shot up in surprise. Jones versus Mayer was a 1968 Supreme Court case that even some practicing attorneys might not readily recall. For a 12-year-old to not only know the case but understand its relevance to contemporary housing law was extraordinary. "You've read Jones versus Mayer?" Antoine asked carefully. "Yes, sir, along with the cases it references and several cases that have cited it since. I've been working on understanding how housing discrimination law has evolved since the Civil Rights Act of 1968. It's fascinating how legal precedent builds on itself over time." What followed was a 2-hour discussion that left Antoine Dubois fundamentally shaken. The child sitting across from him didn't just memorize legal facts. He understood legal concepts, could trace the evolution of constitutional interpretation, and possessed an intuitive grasp of legal strategy that many law school graduates lacked. "Javon," Antoine said finally, his voice soft with wonder, "has anyone ever given you an IQ test or any kind of assessment of your abilities?" "No, sir. Mama says I'm smart, but we don't have money for those kinds of tests. I just read whatever I can find and try to understand it." That evening, Antoine Dubois drove to the small apartment where Javon lived with his mother. The building was in one of Richmond's most challenging neighborhoods, where broken streetlights and broken dreams were equally common. But inside the modest apartment, he found something remarkable: a mother's unwavering dedication and a child's insatiable hunger for knowledge. "Mrs. Washington," Antoine said, accepting the cup of coffee Tamika offered despite its obvious origin in a second-hand coffee maker, "your son is exceptional, not just bright, not just gifted, exceptional in ways that occur maybe once in a generation." Tamika's eyes filled with tears she had held back for months. Finally, someone understood what she had seen in her child, someone with the expertise to validate her instincts and the resources to help. "What does that mean for him?" she asked simply. Antoine leaned forward, his expression serious. "It means we need to be very careful about how we proceed. Javon has the intellectual capacity to understand and practice law at a level that most adults never reach. But he's still a child, and the legal system isn't designed to accommodate someone like him." The conversation that followed laid the groundwork for an unprecedented educational journey. Antoine agreed to mentor Javon privately, providing access to legal resources, real case studies, and the kind of practical experience that no traditional education could offer. The arrangement began with Saturday morning sessions in Antoine's law office. Javon would arrive promptly at 8 a.m., armed with questions about the week's reading assignments and observations about current legal issues. Antoine quickly discovered that traditional mentoring approaches wouldn't work. Javon absorbed information at a rate that required constantly escalating challenges. Within 6 months, Javon was sitting in on client consultations, taking notes, and occasionally offering insights that surprised even Antoine. The boy had developed an uncanny ability to spot weaknesses in legal arguments and identify relevant precedents that others might miss. "He sees patterns," Antoine explained to his law partner one evening. "Most of us learn law by memorizing rules and exceptions. Javon sees law as a living system where everything connects to everything else. It's like he has a three-dimensional map of legal knowledge in his head." The mentoring relationship evolved quickly beyond its original scope. Antoine began bringing Javon to court proceedings, initially as an observer, but increasingly as a participant in case preparation. Judges who knew Antoine well grew accustomed to seeing the serious young boy taking notes in the back of their courtrooms. By age 14, Javon had read more legal texts than many practicing attorneys. His knowledge wasn't just broad, it was deep, nuanced, and practical. He understood not just what the law said, but why it existed, how it had evolved, and where it might be heading. The question that began to consume Antoine's thinking was simple but profound. What do you do with a child who has already surpassed the legal knowledge of most adults? The answer would prove more complex and controversial than anyone could have imagined. By the time Javon Washington reached his 15th birthday, his reputation within Richmond's legal community had begun to spread in whispered conversations and disbelieving anecdotes. Antoine Dubois found himself fielding calls from curious colleagues who had heard improbable stories about a teenager who could cite case law from memory and analyze complex legal problems with the precision of a seasoned attorney. The breakthrough moment came during a particularly challenging case that had stumped Antoine's entire firm. The law office of Dubois and Associates had been retained by a group of elderly residents whose retirement community was being foreclosed upon through what appeared to be fraudulent documentation. The case involved layers of real estate law, elder law, and complex financial regulations that intersected in bewildering ways. For 3 weeks, Antoine and his 2 law partners had worked 18-hour days trying to unravel the legal knots that bound their clients to an inevitable loss of their homes. The opposing counsel represented a well-funded development company with unlimited resources and a team of specialists who seemed to anticipate every legal maneuver Antoine attempted. On a Friday evening in March, as the lawyers sat in their conference room surrounded by boxes of documents and empty coffee cups, Javon quietly entered with his usual weekend reading assignment completed. He paused in the doorway, taking in the scene of legal defeat that was painted across the faces of three exhausted attorneys. "The retirement community case?" Javon asked simply. Antoine nodded wearily. "We're missing something, Javon. There has to be a legal angle we haven't considered, but we've exhausted every approach we can think of." Javon moved to the whiteboard where the lawyers had outlined their legal strategy in a complex web of arrows, case citations, and statutory references. He studied their work for several minutes, his dark eyes moving systematically across the information as if reading a map written in a language only he could understand. "Have you considered a RICO approach?" Javon asked finally. The three attorneys looked at him with expressions of confusion mixed with exhaustion. RICO, the Racketeer Influenced and Corrupt Organizations Act, was typically associated with organized crime prosecutions, not real estate disputes. "RICO doesn't apply to civil real estate matters, son," said David Blake, Antoine's senior partner, not unkindly but with the patience of someone explaining basic legal concepts to a child. Javon moved to the whiteboard and began drawing connections between pieces of information that the lawyers had treated as separate elements. What if it's not just real estate fraud? Look at the pattern of foreclosures across the city. 17 retirement communities, all using similar documentation, all foreclosed within 6 months, all purchased by subsidiaries of the same parent company. As Javon spoke, he wrote case citations and statutory references on the whiteboard with the fluid confidence of someone accessing a vast mental library. The attorneys watched in growing amazement as their young protege outlined a legal theory that reframed their entire understanding of the case. "The documentation irregularities aren't mistakes," Javon continued. "They're part of a systematic scheme to defraud elderly residents of their property. That makes it a pattern of racketeering activity under 18 U.S.C. Section 1962. If we can establish the pattern and the interstate commerce connection through the parent company's operations, we can pursue both civil RICO remedies and treble damages." David Blake sat down heavily in his chair, staring at the whiteboard where Javon had just outlined a legal strategy that none of them had considered. The boy had not only identified a viable approach, he had mapped out the entire prosecution strategy complete with relevant case law and procedural requirements. "How did you see this?" Antoine asked quietly. Javon shrugged with the unconscious modesty of someone who had learned to downplay their gifts. "I read about similar cases in Florida and Arizona. When I saw the pattern here, I remembered the legal approaches that worked in those jurisdictions. What Javon didn't mention was that his reading had included every major RICO case decided in the past decade, cross-referenced with real estate fraud prosecutions and elder abuse litigation. His mind had automatically recognized patterns that would have taken experienced attorneys weeks to identify if they identified them at all. The RICO strategy not only saved the retirement community, it exposed a multi-state fraud scheme that ultimately led to federal investigations and criminal prosecutions. More importantly for Javon, it established his reputation as something more than just a bright kid with an interest in law. Word of the 15-year-old who had cracked a case that had stumped experienced attorneys spread through Richmond's legal community like wildfire. Judges began to take notice when Antoine brought his young protege to court proceedings. Other attorneys started seeking Javon's input on challenging cases, initially as a curiosity but increasingly with genuine respect for his insights. The attention created new challenges. Javon's high school guidance counselor, Mrs. Patricia Morris, called Tamika Washington with concerns about her son's frequent absences from school. The absences were always explained as family obligations, but Mrs. Morris suspected something else was happening. "Mrs. Washington," the counselor said during their conference, "Javon is obviously a bright student, but his priorities seem to be elsewhere. His teachers report that he appears disinterested in classroom discussions, as if the material is beneath him. He completes assignments perfectly but without engagement." Tamika Washington found herself in an impossible position. She couldn't explain that her son was spending his time in law offices and courtrooms because he had already mastered material far beyond high school level. Such an explanation would sound like parental delusion rather than documented fact. "Javon is going through a challenging time," Tamika said carefully. "He's trying to figure out his future path. I'm working with him to ensure his education remains a priority." The conversation highlighted a growing problem that Antoine had begun to recognize. Javon's intellectual development had outpaced not just his chronological age, but also the institutional structures designed to nurture young talent. Traditional educational pathways seemed increasingly irrelevant to someone who was already operating at a professional level. The solution, when it came, emerged from an unexpected source. Professor Margaret Chen at the University of Virginia Law School had heard about the Richmond teenager through professional networks and academic gossip. As a specialist in gifted education and legal pedagogy, Professor Chen was intrigued by reports of someone so young displaying such advanced legal reasoning. She reached out to Antoine with a proposal that was both unprecedented and carefully structured. The University of Virginia Law School had provisions for exceptional students to audit courses and participate in academic programs before formal admission. If Javon could demonstrate the requisite knowledge and maturity, he might be able to participate in selected law school activities while continuing his high school education. The evaluation process was rigorous and comprehensive. Javon spent an entire weekend at the law school, taking examinations, participating in mock trials, and engaging in legal analysis that would challenge third-year law students. Professor Chen and her colleagues designed tests that would assess not just knowledge but also reasoning ability, ethical understanding, and emotional maturity. The results were extraordinary. Javon scored higher on constitutional law assessments than most law school graduates. His analysis of complex legal problems demonstrated not just knowledge but wisdom that typically developed only through years of practice. Most remarkably, his responses to ethical dilemmas showed a sophisticated understanding of professional responsibility that impressed even seasoned legal educators. "I've been teaching law for 23 years," Professor Chen told the evaluation committee. "I've never encountered anyone at any age who demonstrates such comprehensive legal understanding combined with genuine ethical reasoning. This young man isn't just academically gifted, he's intuitively suited for legal practice in ways that can't be taught." The committee's unanimous recommendation led to an arrangement that was probably unique in American legal education. Javon would spend his final 2 years of high school in a hybrid program, completing his secondary education requirements while simultaneously participating in law school courses and clinical programs. The arrangement required careful navigation of academic regulations, age restrictions, and professional guidelines. Javon couldn't officially enroll in law school courses, but he could participate as a special student in selected programs. He couldn't represent clients in official capacities, but he could assist with research and case preparation under close supervision. For Javon, the university experience was revelatory. Surrounded by motivated adults who shared his passion for legal reasoning, he flourished in ways that high school had never allowed. His contributions to law school discussions impressed professors and students alike. His research abilities exceeded those of most graduate students. His analytical insights consistently added value to complex legal projects. More importantly, the university environment provided Javon with peers who could appreciate his gifts without feeling threatened by them. Law students, accustomed to academic competition and intellectual rigor, accepted Javon as a colleague rather than viewing him as an anomaly. By his 17th birthday, Javon Washington had completed the equivalent of 2 years of law school education while maintaining perfect grades in his high school coursework. His knowledge of legal principles surpassed that of many practicing attorneys. His understanding of legal procedure rivaled that of experienced litigators. The question that consumed everyone who knew him was simple. What comes next for someone who has already achieved what most people spend decades trying to accomplish? The answer would prove more controversial than anyone anticipated. The letter arrived on a Tuesday morning in April, delivered to the modest apartment where Javon Washington lived with his mother by a courier service that typically handled only the most important legal documents. Tamika Washington signed for the thick envelope with trembling hands, recognizing the return address of the Virginia State Bar Association, but unable to imagine why such an organization would be corresponding with her 17-year-old son. Inside, she found documents that would have been incomprehensible to her just 3 years earlier. Now, after years of watching her son's extraordinary journey through the legal world, she understood enough to realize she was holding something unprecedented, an invitation for Javon to sit for the Virginia bar examination. The path to this moment had been complex, controversial, and, at times, seemingly impossible. It began 6 months earlier when Professor Margaret Chen, who had become Javon's unofficial academic advisor, raised a question that would ultimately reshape their understanding of legal education and professional requirements. What exactly prevents someone from taking the bar examination if they can demonstrate equivalent knowledge and competence? Professor Chen had asked during a faculty meeting at UVA Law School. The question seemed academic at first. Virginia law, like that of most states, required candidates to graduate from an accredited law school before sitting for the bar examination. The requirement existed to ensure that attorneys possessed the necessary knowledge and training to practice law competently. But Professor Chen's question probed deeper into the purpose behind the requirement. If the goal was ensuring competence, and if someone could demonstrate that competence through alternative means, did the specific pathway matter as much as the ultimate result? The discussion that followed consumed weeks of faculty meetings, consultations with legal scholars, and research into historical precedents. What emerged was a fascinating exploration of how professional licensing requirements had evolved over time, and whether those requirements still served their intended purposes in all cases. Professor Chen discovered that Virginia's bar admission rules contained language that, while rarely invoked, potentially allowed for exceptions in extraordinary circumstances. Rule 1A of the Virginia Board of Bar Examiners stated that the board may, in its discretion, waive or modify any requirement for admission to the Virginia State Bar when extraordinary circumstances warrant such action. The language was intentionally vague, designed to provide flexibility in unusual situations that the rulemakers couldn't anticipate, but it opened a legal door that had never been tested in circumstances like Javon's. Professor Chen began building a case for Javon's eligibility that was as comprehensive as any legal brief filed in federal court. She documented his academic achievements, his practical legal experience, his contributions to actual cases, and his demonstrated competence in every area tested by the bar examination. The documentation was impressive. Javon had completed coursework equivalent to a full law school education. His academic performance exceeded that of most law school graduates. His practical experience, gained through his mentorship with Antoine Dubois, included significant contributions to actual legal cases. His knowledge of legal ethics, constitutional law, and civil procedure had been validated through rigorous testing by law school faculty. More importantly, Professor Chen assembled testimonials from judges, practicing attorneys, and legal educators who had worked with Javon directly. Judge Sandra Phillips, who had presided over several cases where Javon assisted with research, wrote, "In 30 years on the bench, I have rarely encountered anyone with such comprehensive understanding of legal principles and procedures. His age is irrelevant to his competence." Antoine Dubois provided detailed documentation of Javon's contributions to legal cases, including the RICO strategy that had saved the retirement community and exposed a multi-state fraud scheme. Javon Washington possesses legal knowledge and analytical abilities that surpass those of many attorneys who have practiced for decades, Antoine wrote. His insights have been instrumental in achieving favorable outcomes for clients in complex litigation. The petition submitted to the Virginia Board of Bar Examiners was unprecedented in American legal history. It requested permission for a 17-year-old high school student to sit for the bar examination based on demonstrated competence rather than traditional educational credentials. The response from the legal establishment was swift and polarized. Some viewed the petition as a dangerous precedent that could undermine the integrity of legal education and professional licensing. Others saw it as a long overdue recognition that competence should matter more than credentials. The Virginia State Bar Association found itself facing a decision with implications far beyond Javon's individual case. If they approved his petition, they would be acknowledging that traditional legal education wasn't the only path to professional competence. If they denied it, they would be suggesting that demonstrated ability was less important than institutional requirements. The Board of Bar Examiners scheduled hearings that attracted national attention. Legal scholars, educators, and practitioners from across the country submitted briefs supporting or opposing Javon's petition. Media coverage ranged from supportive profiles of a remarkable young talent to critical analyses of challenges to established professional standards. Javon himself remained surprisingly calm throughout the controversy. He continued his studies, assisted Antoine with ongoing cases, and maintained his high school coursework with the same systematic dedication that had characterized his entire educational journey. "I'm not trying to challenge the system," he told reporters who managed to track him down at the law school. "I'm just trying to use my abilities to help people. If that means taking the bar examination, then I'll take it. If it means finding another path, I'll find another path." His mature response to the media attention impressed even his critics. Here was not a publicity-seeking teenager trying to break rules for personal gain, but a serious young person who had dedicated years to mastering his craft and simply wanted to practice it professionally. The hearings before the Board of Bar Examiners took place over 3 days in November. Javon arrived each morning with Antoine Dubois, dressed in his best suit and carrying a briefcase filled with documentation that supported his petition. The hearing room was packed with observers, including legal reporters, law school faculty, practicing attorneys, and curious members of the public. Board Chairman Robert Morrison, a distinguished attorney with 40 years of practice experience, presided over the proceedings with careful attention to both legal precedent and the broader implications of their decision. The board consisted of 7 members, each bringing different perspectives to the unprecedented question before them. "Mr. Washington," Chairman Morrison began on the first day of hearings, "you understand that what you're requesting has never been granted in Virginia's history. You're asking us to waive requirements that have existed for decades to ensure the competence and professionalism of attorneys admitted to practice in our state." Javon stood to respond, his posture confident but respectful. "Yes, Mr. Chairman, I understand the significance of this request. I'm not asking you to lower standards or compromise the integrity of the legal profession. I'm asking you to evaluate my competence based on demonstrated ability rather than the specific path I took to acquire that ability." Over the following 3 days, Javon underwent the most comprehensive examination of legal knowledge and competence ever administered by the Virginia Bar. Board members and invited experts questioned him on constitutional law, civil procedure, criminal law, evidence, legal ethics, and professional responsibility. They presented him with complex hypothetical scenarios and asked him to analyze legal problems in real time. The examination went far beyond the scope of a typical bar examination. Javon was asked to draft legal briefs, analyze judicial decisions, and explain the historical development of various areas of law. He participated in mock client consultations, demonstrating his understanding of attorney-client privilege and professional ethics. Throughout the grueling process, Javon's responses consistently exceeded expectations. His knowledge was not just broad but deep, not just theoretical but practical. He demonstrated understanding of nuanced legal concepts that many practicing attorneys struggled with. His ethical reasoning showed maturity that impressed even skeptical board members. Professor Chen testified on Javon's behalf. providing detailed analysis of his academic performance and contributions to legal scholarship. This young man has completed the equivalent of a rigorous law school education through alternative means, she told the board. His knowledge and competence exceed those of most law school graduates. The question before you isn't whether he's qualified to practice law. The question is whether you have the courage to recognize qualification when it comes through an unconventional path. The opposition testimony was equally passionate. Representatives from law schools argued that bypassing traditional legal education could undermine the entire system of professional preparation. If we allow one person to skip law school, regardless of their abilities, we open the door to others who may not be as qualified, argued Dean Harold Stevens from Richmond Law School. The requirements exist for good reasons that go beyond just knowledge acquisition. The debate reflected deeper questions about professional licensing, educational requirements, and the purpose of institutional credentialing. Was law school attendance about knowledge acquisition, professional socialization, or simply maintaining barriers to entry? Did the legal profession serve itself or the public when it insisted on specific educational pathways? After 3 days of testimony and examination, the Board of Bar Examiners retired to deliberate. Their decision would be unprecedented regardless of the outcome. Approving Javon's petition would establish a new pathway to legal practice. Denying it would reaffirm traditional requirements despite demonstrated competence. The deliberation took 4 hours. When Chairman Morrison returned to announce their decision, the hearing room fell into complete silence. Legal history was about to be made one way or another. The board has reached a unanimous decision, Morrison announced, his voice carrying the weight of historical significance. While we recognize the unprecedented nature of this request, we are convinced that Mr. Washington has demonstrated legal knowledge, analytical ability, and ethical understanding that meet or exceed the standards we expect from licensed attorneys. The room erupted in whispers and murmurs as the implications of the statement sank in. Morrison raised his hand for silence before continuing. Therefore, the board grants Mr. Washington's petition to sit for the Virginia bar examination. We do so with the understanding that this decision is based on extraordinary circumstances and should not be interpreted as a general waiver of educational requirements for future applicants. Javon remained seated, his expression calm, despite the magnitude of what he had just achieved. He had become the youngest person in Virginia history to be granted permission to sit for the bar examination. More significantly, he had forced the legal establishment to acknowledge that competence could be demonstrated through paths other than traditional legal education. The media response was immediate and intense. Legal publications analyzed the implications of the board's decision. News outlets across the country covered the story of the teenager who had convinced state officials to let him attempt to become a licensed attorney. But for Javon Washington, the board's approval was just the beginning. Now he had to actually pass one of the most challenging professional examinations in American society. The bar examination would test not just his legal knowledge, but his ability to apply that knowledge under the intense pressure of time testing. The examination was scheduled for February, giving Javon 3 months to prepare. Those 3 months would prove as challenging as anything he had faced in his extraordinary educational journey. The Virginia bar examination was a 2-day ordeal that had broken the confidence of thousands of law school graduates over the decades. The test covered multiple areas of law through essay questions, multiple choice problems, and practical exercises designed to evaluate not just knowledge but the ability to think like a lawyer under pressure. Javon approached his preparation with the same systematic methodology that had characterized his entire legal education. He obtained past examinations, analyzed successful and unsuccessful answers, and studied the specific format and timing requirements that would govern his performance. Antoine Dubois arranged for Javon to take practice examinations under conditions identical to the actual test. They converted a conference room in the law office into a mock testing facility, complete with the uncomfortable chairs, harsh lighting, and time restrictions that would characterize the actual examination experience. The practice sessions revealed both strengths and areas needing improvement. Javon's knowledge was comprehensive and his analysis was sophisticated, but he struggled initially with the time constraints imposed by the examination format. Legal practice allowed for careful research and thorough consideration of alternatives. The bar examination demanded quick decisions and concise answers within strict time limits. "You're overthinking the questions," Antoine observed after reviewing Javon's first practice session. "Your answers are more thorough than they need to be. The bar examiners want to see that you understand the legal principles and can apply them correctly. They don't need a law review article for each question." Javon spent weeks learning to calibrate his responses to the examination's requirements. He practiced writing concise answers that demonstrated competence without unnecessary elaboration. He learned to recognize when a question was testing basic knowledge versus analytical ability. The hardest part wasn't the legal knowledge, it was adapting his natural approach to learning and analysis to the artificial constraints of a standardized test. Javon was accustomed to exploring legal questions thoroughly, following logical connections wherever they led. The bar examination required him to provide specific answers to specific questions within specific time limits. Professor Chen helped him develop testing strategies that would maximize his performance. "Remember that this is a test of minimum competence, not maximum knowledge," she advised. "Your goal isn't to impress the graders with your brilliance. Your goal is to demonstrate that you meet the basic requirements for legal practice." The weeks leading up to the examination were intense. Javon maintained his high school coursework while spending every available hour preparing for the test that would determine his professional future. His mother watched him study with a mixture of pride and concern, recognizing both his dedication and the enormous pressure he was placing on himself. "Baby, you don't have anything to prove to anybody," Tamika told him one evening as she found him surrounded by study materials at their kitchen table. "You've already accomplished more than most people do in their entire careers." Javon looked up from his constitutional law outline, his eyes reflecting the weight of expectation he carried. "It's not about proving anything, Mama. It's about being able to help people. All this knowledge doesn't mean anything if I can't use it to make a difference." The examination took place at the Richmond Convention Center, where hundreds of aspiring attorneys gathered for 2 days of testing that would determine their professional futures. Javon arrived early both days, his mother dropping him off with the same mixture of encouragement and nervousness she had shown before his first day of kindergarten. The other test takers were mostly in their 20s. Recent law school graduates carrying the confidence or anxiety that came with 3 years of intensive legal education. Javon, at 17, drew curious glances from his fellow examinees who couldn't understand why someone so young was taking the test. The examination itself was as challenging as Javon had expected. The essay questions required comprehensive analysis of complex legal problems within strict time constraints. The multiple-choice section tested detailed knowledge of legal rules and their applications across multiple jurisdictions. Javon approached each section methodically, drawing upon years of study and practice to navigate the challenging questions. His hand moved steadily across the pages, filling blue books with analyses of contract disputes, constitutional questions, and criminal law problems. During the lunch break on the first day, several other test takers approached Javon with curiosity about his presence. When they learned he was still in high school, their reactions ranged from disbelief to admiration to concern about the competition he might represent. "I've never heard of anyone taking the bar examination before graduating from law school," said Jennifer Martinez, a recent graduate from Virginia Commonwealth University Law School. "How did you even qualify to take it?" Javon explained his situation briefly, focusing on the board's decision to allow him to demonstrate competence through alternative means. He didn't want to seem boastful or to create unnecessary tension with people who were already dealing with examination stress. By the end of the second day, Javon felt confident about his performance but uncertain about the outcome. The bar examination was graded anonymously, with his answers evaluated alongside those of hundreds of other candidates. His age and background would be irrelevant to the graders, who would determine whether his responses met the standards for admission to practice. The waiting period after the examination was perhaps more challenging than the preparation had been. Results wouldn't be announced for 2 months, leaving Javon in a state of suspended animation between his extraordinary preparation and an uncertain future. He returned to his regular routine of high school classes and work with Antoine, but the pending bar results cast a shadow over everything he did. If he passed, he would become the youngest licensed attorney in Virginia history. If he failed, he would face questions about whether his unconventional education had adequately prepared him for professional practice. The legal community watched and waited along with Javon. His story had captured national attention, and his success or failure would be seen as a validation or rejection of alternative approaches to legal education. 2 months after the examination, on a Thursday morning in April, Javon received an envelope from the Virginia Board of Bar Examiners. Unlike the previous correspondence that had contained lengthy documents and explanations, this envelope was thin, containing only a single sheet of paper. Javon stared at the envelope for several minutes before opening it, knowing that its contents would determine the trajectory of his entire life. Finally, with hands that trembled only slightly, he tore open the seal and read the words that would make legal history. He had passed. Not only had he passed, but his scores placed him in the top 10% of all candidates who had taken the examination. Javon Washington, at 17 years old, was now a licensed attorney in the Commonwealth of Virginia. The news spread through the legal community within hours. Media outlets that had followed his story reported his success with headlines that emphasized both his achievement and its unprecedented nature. Law schools that had opposed his unconventional path found themselves having to acknowledge his competence. More importantly for Javon, the bar passage meant he could now legally represent clients, appear in court as an attorney, and practice law in all its forms. The knowledge and skills he had spent years developing could finally be used in their intended professional context. But Javon Washington's story was far from over. Being licensed to practice law was one thing. Being accepted and respected by judges, juries, and the legal establishment was another challenge entirely. That challenge would begin in a small courtroom in Richmond, where a teenager would face a judge who had no idea that the young man standing before him was about to rewrite everything he thought he knew about legal competence and professional capability. The brass nameplate outside the modest law office read Dubois and Associates in simple black lettering, but the newest associate's name didn't appear anywhere on the building directory. Javon Washington had officially joined Antoine's practice as the youngest licensed attorney in Virginia, but they had agreed to introduce his involvement gradually to avoid the media circus that might overwhelm both their clients and their work. Javon's first official case as a licensed attorney was a straightforward contract dispute involving a small business owner who had been defrauded by a supplier. The client, Mrs. Dorothy Henderson, owned a neighborhood grocery store and had ordered merchandise that was never delivered despite full payment in advance. "I've been trying to get my money back for 6 months," Mrs. Henderson explained during their initial consultation. "The supplier keeps making excuses, but I need that $3,000 to keep my store running. My lawyer says it's not worth pursuing because the legal fees would cost more than I could recover." Javon listened carefully, taking notes and asking questions about the timeline of events, documentation, and previous attempts at resolution. His approach was thorough but efficient, demonstrating the systematic thinking that had characterized his legal education. "Mrs. Henderson," Javon said after reviewing her documents, "there are several approaches we can take to recover your money. The most direct would be a breach of contract claim, but I think we might also have grounds for fraud allegations that could result in treble damages." Mrs. Henderson looked uncertain, glancing between Javon and Antoine. Despite Javon's obvious competence, his youthful appearance made her hesitant about trusting him with her important legal matter. Antoine recognized her concern and addressed it directly. "Mrs. Henderson, I understand your hesitation about Javon's age, but I can tell you with absolute confidence that he's one of the most knowledgeable attorneys I've ever worked with. He's licensed by the same state bar that licensed me, and he's held to the same professional standards." Over the following weeks, Javon demonstrated those professional standards through meticulous preparation and creative legal strategy. He researched the supplier's business practices and discovered a pattern of similar complaints from other small business owners. What had initially appeared to be a simple contract dispute was actually part of a systematic scheme to defraud minority-owned businesses. Javon's approach to the case combined traditional legal research with innovative use of public records and business databases. He traced the supplier's corporate structure, identified previous legal actions, and built a comprehensive picture of fraudulent conduct that extended far beyond Mrs. Henderson's individual case. The legal brief Javon filed in Richmond Circuit Court was a masterpiece of legal writing that impressed even seasoned attorneys who had practiced for decades. He not only established grounds for breach of contract recovery, but also documented patterns of fraudulent conduct that justified enhanced damages and attorneys' fees. The opposing counsel, a mid-level attorney from a downtown firm, initially underestimated both the strength of Javon's legal position and his competence as an advocate. The assumption seemed to be that a young attorney working on a small contract case wouldn't have the resources or expertise to mount a serious challenge. That assumption proved costly during depositions, where Javon demonstrated comprehensive knowledge of commercial law, fraud statutes, and civil procedure. His questioning of the supplier's representatives was precise, thorough, and devastatingly effective. By the end of the deposition phase, the opposing counsel was scrambling to develop settlement proposals. "Your young associate is quite impressive," the opposing attorney told Antoine during settlement negotiations. "I have to admit, I didn't expect such sophisticated legal work on what seemed like a routine contract dispute." The case settled for significantly more than Mrs. Henderson's original damages, including attorney's fees and additional compensation for the delay and inconvenience she had suffered. More importantly for the broader community, the investigation Javon conducted led to criminal referrals and a state investigation of fraudulent business practices targeting minority entrepreneurs. Word of Javon's success spread through Richmond's black business community, leading to additional clients who had been victimized by similar schemes or who faced other legal challenges that mainstream law firms considered too small to handle profitably. His second major case involved a family facing foreclosure due to predatory lending practices. The Johnson family had refinanced their home through a company that used deceptive practices to lock them into terms they couldn't afford. When they fell behind on payments, the lender accelerated the foreclosure process without following proper legal procedures. Javon's analysis of the case revealed multiple violations of federal and state lending regulations, improper foreclosure procedures, and documentation irregularities that invalidated the lender's claim to the property. His legal research uncovered recent court decisions that provided strong precedential support for challenging the foreclosure. The foreclosure defense required Javon to appear in court for the first time as a licensed attorney representing clients. The presiding judge, the Honorable Margaret Phillips, had been practicing law when Javon was born and had never encountered an attorney as young as the one standing before her bench. "Counselor Washington," Judge Phillips said during their first hearing, "I have to ask, are you actually licensed to practice in Virginia?" Javon responded with calm professionalism, providing his bar number and offering to submit documentation of his admission to practice. Judge Phillips verified his credentials and allowed the proceeding to continue, but her initial skepticism was evident throughout the hearing. Despite the judge's obvious doubts, Javon's legal arguments were sound and his presentation was professional. He cited relevant statutes, referenced applicable case law, and demonstrated comprehensive understanding of foreclosure procedure. His motion to dismiss the foreclosure action was based on solid legal grounds that the opposing counsel struggled to address. "I'm going to take this motion under advisement," Judge Phillips announced after hearing arguments from both sides. "But I must say, Mr. Washington, your legal analysis is quite thorough for someone so young. Where did you attend law school?" Javon's explanation of his unconventional path to bar admission created a stir in the courtroom that extended beyond the specific case at hand. Judge Phillips had heard about the teenager who had been granted permission to take the bar examination, but she hadn't realized that the same young man was now appearing before her as a practicing attorney. The foreclosure case ultimately resulted in a complete victory for the Johnson family. Javon's legal research and advocacy not only saved their home, but also resulted in financial compensation for the damages they had suffered due to the lender's illegal practices. More significantly, the case established Javon's reputation within the local legal community as a serious advocate who could achieve results for his clients regardless of his age. Judges who had initially been skeptical of his presence began to treat him with the same professional respect accorded to more experienced attorneys. The third case that shaped Javon's early practice involved a civil rights violation that had been ignored by other attorneys due to its complexity and the limited financial resources of the potential client. Marcus Thompson, a young black man, had been subjected to excessive force during a traffic stop that left him with permanent injuries and no legal recourse through the criminal justice system. Javon's investigation of the case revealed patterns of misconduct by the officers involved, departmental policies that facilitated abuse, and a history of similar incidents that had been covered up or ignored. His legal strategy combined civil rights claims with state tort actions and constitutional violations that created multiple avenues for recovery. The civil rights case required Javon to navigate federal court procedures, complex constitutional law, and the sophisticated legal defenses typically mounted by government entities. The opposing counsel included experienced attorneys from the city's legal department who specialized in defending against police misconduct claims. Javon's preparation for the case was exhaustive. He studied every aspect of Fourth Amendment jurisprudence, researched similar cases from across the country, and developed innovative legal theories that addressed the specific circumstances of his client's situation. His legal briefs cited hundreds of cases and synthesized complex constitutional principles into clear, compelling arguments. The federal judge assigned to the case, the Honorable William Harrison, was initially surprised by the youthful appearance of the plaintiff's counsel, but quickly became impressed by the quality of Javon's legal work. His motions were well-researched, his arguments were sophisticated, and his understanding of civil rights law rivaled that of attorneys with decades of experience. During pretrial proceedings, Javon's depositions of the police officers involved revealed inconsistencies in their testimonies and evidence of attempts to cover up the excessive force incident. His questioning was methodical and legally precise, creating a comprehensive record that would support his client's claims at trial. The case ultimately settled for a significant amount that provided Marcus Thompson with compensation for his injuries and established important precedents regarding police accountability. More importantly, the settlement included policy changes within the police department that would provide better protection for citizens in the future. By the end of his first year of practice, Javon Washington had established himself as a formidable advocate for clients who had been overlooked or underserved by the legal system. His cases consistently achieved results that exceeded expectations, and his legal skills had earned respect from judges, opposing counsel, and clients alike. But Javon's most significant challenge was yet to come. It would arrive in the form of a simple traffic citation that would ultimately test everything he had learned about law, justice, and the courage required to stand up for one's principles in the face of institutional prejudice. That test would unfold in courtroom 4B, where Judge Robert Whitmore was about to encounter the consequences of his own assumptions and prejudices. The evening that would ultimately lead Javon Washington to courtroom 4B began with a community meeting in the basement of Mount Olive Baptist Church. The fluorescent lights cast harsh shadows across folding chairs arranged in uneven rows, while a few dozen residents gathered to discuss the ongoing gentrification that was transforming their historically black neighborhood. Javon attended the meeting with his mother, drawn by his growing interest in using legal advocacy to address systemic issues affecting the community where he had grown up. At 18, he had already handled dozens of cases as a licensed attorney, but he remained deeply connected to the neighborhood that had shaped his understanding of justice and inequality. The meeting was organized by the East Richmond Community Coalition, a grassroots organization formed to address the displacement of longtime residents by developers who purchased homes at below-market prices and converted them into expensive condominiums. The practice was legal, but devastating to families who had lived in the neighborhood for generations. Mrs. Betty Williams, a retired teacher who had lived in East Richmond for 40 years, stood at the front of the room describing how developers had pressured her elderly neighbors to sell their homes for fractions of their actual value. Her voice carried the frustration of someone who had watched her community disintegrate one property sale at a time. "They come to your door with cash offers," Mrs. Williams explained to the assembled residents. "They tell you your house isn't worth much, that you should take their offer before property values decline. But then they turn around and sell those same houses for 3 times what they paid." The stories shared that evening painted a picture of systematic exploitation that targeted elderly residents, families facing financial difficulties, and property owners who lacked knowledge about real estate values and their legal rights. The developers' practices, while technically legal, violated the spirit of fair dealing and community preservation. Javon listened carefully to each resident's testimony, taking notes and asking questions about documentation, timelines, and attempts to seek legal assistance. His legal training had taught him to recognize patterns of conduct that might be actionable even when individual incidents seemed isolated. When Mrs. Williams asked if anyone had ideas about how the community could protect itself from further exploitation, Javon stood up from his seat in the back of the room. Several residents turned to look at the young man who had been quietly taking notes throughout the evening. "I'm Javon Washington," he began, his voice carrying the same measured tone he used in courtrooms. "I'm an attorney, and I've been listening to your stories with both personal concern as a member of this community and professional interest as someone who understands property law and consumer protection." The introduction created a stir among the residents, many of whom had never met a lawyer who actually lived in their neighborhood. The attorneys they encountered typically worked for the other side, representing landlords, developers, or government agencies that seemed indifferent to community concerns. Javon continued, "What you're describing sounds like it might involve unfair and deceptive business practices that violate Virginia's consumer protection laws. While individual sales might be legal, a pattern of targeting vulnerable residents with misleading information about property values could constitute fraud." Mrs. Williams looked hopeful for the first time all evening. "You really think there's something we can do legally? Every lawyer I've called says the sales are legitimate, and there's nothing anyone can do to stop them." "The sales might be legally binding once they're completed," Javon explained, "but that doesn't mean the process used to obtain them was legal. If developers are systematically misleading property owners about market values, using high-pressure tactics, or targeting vulnerable residents, they might be violating laws that provide remedies for affected families." The discussion that followed lasted another 2 hours, with residents sharing additional details about their interactions with developers and Javon explaining various legal protections that might apply to their situations. He offered to research their concerns and provide additional guidance at a follow-up meeting. As the gathering concluded, Javon found himself surrounded by residents who wanted to discuss their individual situations. An elderly man named Samuel Johnson described how developers had convinced his sister to sell her house by telling her the neighborhood was declining and she should get out while she could. A single mother named Patricia Davis explained how she had been pressured to sign documents she didn't fully understand during a high-pressure sales presentation. The stories revealed a coordinated effort to destabilize the community through deceptive practices that targeted the most vulnerable residents. Javon realized he was looking at a potential class action lawsuit that could not only compensate affected families but also establish legal precedents that would protect other communities facing similar threats. Over the following weeks, Javon conducted extensive research into the developer's business practices, property records, and legal precedents that might support community-wide litigation. He discovered that the primary development company had used similar tactics in other historically black neighborhoods across Virginia, always targeting areas where residents lacked access to legal representation or knowledge about their rights. His investigation revealed patterns of conduct that clearly violated Virginia's Consumer Protection Act, including systematic misrepresentation of property values, high-pressure sales tactics targeting elderly residents, and failure to disclose material information about planned development projects that would affect neighborhood character. Armed with this research, Javon organized a second community meeting to present his findings and discuss legal options available to affected residents. The meeting was better attended than the first, with word having spread about the young lawyer who was offering to help the community fight back against gentrification. Based on my research, Javon told the assembled residents, I believe we have grounds for a class action lawsuit that could provide compensation for families who were defrauded and injunctive relief that would prevent similar practices in the future. The legal strategy he outlined was comprehensive and innovative. Rather than simply pursuing individual claims for fraudulent real estate transactions, Javon proposed a broader civil rights approach that would frame the developer's practices as discriminatory conduct that violated federal fair housing laws and constitutional equal protection principles. What makes this particularly actionable, Javon explained, is that the defendant specifically targeted a historically black neighborhood using tactics designed to exploit racial and economic vulnerabilities. That transforms individual contract disputes into civil rights violations with enhanced remedies and federal jurisdiction. The residents voted unanimously to authorize Javon to file the lawsuit on their behalf. The decision represented more than just a legal strategy. It was a community's decision to fight for its survival using the legal system that had historically been used to facilitate their displacement. Javon spent the next month preparing what would become one of the most significant civil rights cases filed in Virginia in recent years. The complaint named not only the primary development company, but also real estate agents, financial institutions, and local officials who had facilitated the discriminatory practices. The filing of Washington v. Richmond Development Corporation generated immediate media attention and strong reactions from both supporters and opponents of gentrification. Community advocates praised the innovative legal approach that addressed systemic displacement through civil rights enforcement. Development interests criticized the lawsuit as an attack on legitimate business practices and property rights. More significantly for Javon personally, the case established his reputation as an attorney willing to take on powerful interests when communities were being harmed by systematic discrimination or exploitation. His legal work was attracting attention from civil rights organizations, legal scholars, and community advocates across the state. But the case also made him enemies among people who benefited from the status quo and who resented having their practices challenged by a young black attorney from the affected community. Those enemies would soon find ways to retaliate against both Javon and the community he was fighting to protect. The retaliation began subtly, with increased police presence in the neighborhood and stricter enforcement of ordinances that had previously been ignored. Community meetings were monitored by officers who claimed to be ensuring public safety, but whose presence intimidated residents and discouraged participation in the lawsuit. 3 months after filing the civil rights case, Javon found himself driving home from a late-night strategy session with community leaders when he noticed the police car that had been following him for several blocks. The traffic stop that followed would set in motion events that would test not only Javon's legal knowledge but also his courage in the face of institutional retaliation. As he pulled over to the side of the road that night, Javon Washington had no way of knowing that he was about to face the most significant challenge of his young career. The confrontation that was coming would expose the very prejudices and assumptions he had spent his life overcoming through excellence, preparation, and unwavering commitment to justice. The flashing red and blue lights in his rearview mirror represented more than just a traffic stop. They were the opening moves in a battle that would ultimately play out in courtroom 4B, where a biased judge would learn exactly what happens when institutional prejudice confronts exceptional competence armed with the full power of the law. The night air was crisp with the promise of autumn as Javon Washington drove through the quiet streets of East Richmond, his mind still focused on the legal strategies discussed during the evening's community meeting. The dashboard clock read 11:47 p.m. as he navigated the familiar route toward his apartment, his car's headlights cutting through the darkness of the residential neighborhood he had called home for most of his life. The meeting had been productive but tense, with community leaders expressing growing concern about the increased police presence that had coincided with their civil rights lawsuit against Richmond Development Corporation. Several residents reported being stopped for minor infractions that had never been enforced before, while others described a general atmosphere of intimidation that seemed designed to discourage their participation in the legal action. Javon had advised the community leaders to document every interaction with law enforcement, explaining that patterns of harassment related to their lawsuit could constitute additional civil rights violations. But even as he provided legal counsel, he couldn't shake the feeling that the retaliation against the community was intensifying and becoming more systematic. As he approached the intersection of Broad Street and 25th Avenue, Javon came to a complete stop at the red traffic signal, his hands positioned precisely at 10 and 2 on the steering wheel. The intersection was well lit and equipped with traffic cameras, making it one of the safest spots in the neighborhood for both drivers and pedestrians. The light changed to green, and Javon proceeded through the intersection with careful attention to the speed limit and traffic patterns. His driving had always been cautious and precise, habits developed during his teenage years when his mother had impressed upon him the additional scrutiny that young black men faced from law enforcement. 3 blocks past the intersection, Javon noticed the police cruiser that had fallen in behind him. The officer maintained a following distance that seemed professional rather than threatening, and Javon initially assumed it was simply a routine patrol in a neighborhood that had seen increased police activity in recent months. But when the cruiser continued to follow him through several turns, Javon began to suspect that he was being deliberately tailed. His legal training had taught him to recognize surveillance techniques, and the police car's movements suggested active monitoring rather than coincidental travel along similar routes. Javon maintained his careful adherence to all traffic regulations, ensuring that his speed remained within legal limits and his lane changes were properly signaled. He knew that providing any legitimate basis for a traffic stop could lead to complications that would be difficult to address later, regardless of his professional credentials. The blue and red lights activated without warning as Javon approached another intersection, their flashing reflection filling his rearview mirror with official authority. He experienced a moment of confusion, mentally reviewing his driving during the previous several minutes and finding no basis for legitimate police intervention. Following the protocols he had learned both through legal education and community wisdom, Javon immediately activated his hazard lights and began looking for a safe location to pull over. He chose a well-lit area in front of a convenience store, positioning his vehicle where security cameras would have clear views of the traffic stop. As he brought his car to a complete stop and turned off the engine, Javan activated his phone's recording function and placed it in the cup holder where it would capture audio of the interaction. The practice was legal in Virginia and provided protection for both citizens and officers during potentially controversial encounters. Two officers emerged from the patrol car, their movements deliberate and professional as they approached Javan's vehicle from both sides. The primary officer, a tall white man in his 30s with a military bearing, positioned himself at the driver's side window while his partner, a shorter officer with nervous energy, took a position near the rear of the vehicle. Javan kept his hands visible on the steering wheel and waited for the officers to initiate contact, following protocols designed to minimize the risk of misunderstanding or escalation. His years of legal practice had taught him that traffic stops were among the most dangerous interactions between police and citizens, particularly for young black men. "Good evening," the primary officer said as he approached the window, his flashlight beam sweeping across Javan's face and the interior of the vehicle. "I'm Officer Bradley Stevens with the Richmond Police Department. Do you know why I stopped you tonight?" Javan responded with careful politeness. "Good evening, Officer Stevens. No, sir, I don't know why you stopped me. I believe I was following all traffic regulations." Officer Stevens's expression suggested skepticism as he leaned slightly closer to the window. "License and registration, please, and keep your hands where I can see them while you retrieve the documents." The request was standard procedure, but Stevens' tone carried an edge that made Javan wary. He carefully reached for his glove compartment, narrating his movements to avoid any misunderstanding about his intentions. "I'm reaching into my glove compartment now to get my registration," Javan said clearly. "My driver's license is in my wallet in my back pocket." As Javan handed over his documents, Officer Stevens examined them with unusual scrutiny, taking longer than necessary to review the straightforward information. His partner, who had been observing from the rear of the vehicle, moved closer to participate in the interaction. "Mr. Washington," Officer Stevens said finally, "you were observed failing to come to a complete stop at the intersection of Broad and 25th Avenue. That's a moving violation that carries both fines and points against your driving record." Javan's brow furrowed slightly as he processed the allegation. He was absolutely certain that he had come to a complete stop at the intersection, which was equipped with traffic cameras that would corroborate his version of events. "Officer Stevens," Javan replied respectfully, "I believe there may be some mistake. I'm certain that I came to a complete stop at that intersection. Perhaps we could review the traffic camera footage to clarify what happened." The suggestion seemed to irritate Officer Stevens, whose demeanor shifted from professional to confrontational. His partner, Officer Daniel Murphy, moved closer to the driver's side window, creating an atmosphere of increased tension around the vehicle. "Are you arguing with me, Mr. Washington?" Stevens asked, his voice hardening. "Are you telling me I don't know how to do my job?" Javan maintained his respectful tone despite the officer's obvious hostility. "Not at all, Officer Stevens. I'm simply stating what I observed from my perspective. I have great respect for law enforcement and the difficult job you do." The response should have de-escalated the situation, but Stevens seemed determined to find conflict where none existed. He handed Javan's documents to his partner and stepped back from the vehicle, engaging in a whispered conversation that lasted several minutes. During the conversation, Javan noticed Officer Murphy pointing toward the rear of his vehicle and making gestures that seemed to indicate they were discussing something other than the alleged traffic violation. The extended discussion, combined with their body language, suggested that the traffic stop was evolving into something more complex. When the officers returned to his window, Stevens' expression had hardened into something approaching hostility. "Mr. Washington, we're going to need you to step out of the vehicle. We have reasonable suspicion that you may be involved in illegal activity." The escalation from a simple traffic stop to criminal investigation happened so quickly that Javan initially struggled to process what was occurring. His legal training kicked in automatically, providing him with knowledge about his rights and the officer's limitations during investigatory stops. "Officer Stevens," Javan said carefully, "may I ask what specific illegal activity you suspect me of?" I believe I have the right to understand the basis for your investigation. Stevens's face flushed with anger at what he apparently viewed as continued defiance. You have the right to cooperate with a lawful police investigation. Now step out of the vehicle before this situation gets worse for you. Javon complied with the order while continuing to assert his legal rights in measured tones. I'm stepping out of the vehicle as you've requested. I want to cooperate fully while also exercising my constitutional rights. May I ask if I'm being detained or if I'm free to leave? The question seemed to further anger Stevens, who apparently interpreted legal knowledge as disrespect for his authority. As Javon stood beside his vehicle with his hands visible, both officers positioned themselves in ways that created physical intimidation while maintaining the appearance of standard procedure. You're being detained pending our investigation, Stevens announced. We have reports of drug activity in this area, and your behavior tonight has been consistent with someone attempting to avoid law enforcement detection. Javon's confusion was genuine and evident. His behavior had been completely lawful and cooperative, following every protocol designed to ensure safe interactions between citizens and police officers. The allegation that his conduct suggested criminal activity seemed completely unfounded. Officer Stevens, I respectfully disagree with that characterization. I've been cooperative throughout this interaction and have violated no laws. May I ask what specific behaviors you're interpreting as suspicious? Instead of answering the question, Stevens nodded to his partner, who moved to the rear of Javon's vehicle and began examining the trunk area. Murphy's inspection was thorough and deliberate, as if he were searching for something specific rather than conducting a general safety check. We're going to search your vehicle, Stevens announced. If you have nothing to hide, you shouldn't have any objection to us making sure everything is legal. Javon's legal training immediately activated his understanding of Fourth Amendment protections and the limitations on police search authority. A traffic stop did not automatically authorize a vehicle search without either consent, probable cause, or specific safety concerns. Officer Stevens, I don't consent to a search of my vehicle. I understand you need either my consent, a warrant, or probable cause to conduct such a search. Has something occurred to establish probable cause? The assertion of constitutional rights seemed to infuriate both officers, who apparently viewed legal knowledge as evidence of criminal sophistication rather than civic education. Stevens moved closer to Javon, using his physical presence as an intimidation tactic. Your refusal to consent suggests you have something to hide, Stevens said aggressively. That gives us reasonable suspicion to conduct a protective search for officer safety. Javon remained calm despite the escalating tension, drawing upon years of legal education and community wisdom about police encounters. Officer Stevens, I understand your safety concerns, but I want to be clear that I'm not consenting to any search while also not physically resisting your actions. The carefully worded response preserved Javon's legal rights while avoiding any conduct that could be characterized as obstruction or interference with police duties. His statement created a clear record of his position without escalating the confrontation to physical resistance. Murphy's search of the vehicle's exterior quickly focused on the trunk area, where he spent several minutes examining the locking mechanism and the interior space visible through the rear window. His behavior suggested familiarity with the vehicle's layout, as if he had observed it previously. Stevens, you need to see this, Murphy called from the rear of the vehicle, his voice carrying a tone of manufactured discovery. Javon watched as Stevens joined his partner at the trunk, where Murphy was pointing to something that apparently required both officers' attention. Their whispered conversation was animated and purposeful, suggesting coordination rather than spontaneous investigation. When Stevens returned to face Javon, his expression carried the satisfaction of someone who had found what he was looking for. Mr. Washington, we're going to need to search your trunk. Officer Murphy has observed something that establishes probable cause. The claim struck Javon as suspicious, given that the trunk had been closed throughout the encounter and Murphy's observation had come only after an extended search of areas where nothing should have been visible. But he maintained his professional demeanor while continuing to assert his rights. What specifically has Officer Murphy observed that establishes probable cause? Jovan asked. I believe I have the right to understand the legal basis for the search. Stevens ignored the question and instead demanded Javon's car keys, which he reluctantly provided after stating clearly that he was not consenting to the search but was complying under protest to avoid physical confrontation. The trunk opened with a metallic click that seemed to echo through the quiet night. Murphy's flashlight beam swept across the interior space, illuminating the spare tire, emergency kit, and legal briefcase that constituted Javon's normal trunk contents. But there was something else, something that definitely had not been there when Jovan had loaded his trunk earlier that evening. A small plastic bag containing white powder sat conspicuously near the edge of the trunk space, positioned in a way that would be immediately visible to anyone opening the trunk. Javon's heart rate accelerated as he realized what was happening. The substance had been planted in his vehicle, almost certainly during the extended period when both officers had been at the rear of his car engaged in whispered conversations. Well, Stevens said with theatrical surprise. What do we have here? Mr. Washington, can you explain why there's what appears to be narcotics in your trunk? The question was posed with obvious satisfaction, as if Stevens had expected to find exactly what he had discovered. Javon's legal mind immediately began analyzing the situation, recognizing the systematic nature of what was occurring and the careful way the officers had constructed their narrative. Officer Stevens, I have never seen that substance before, and I can state categorically that it was not in my trunk when I left home this evening. I believe this substance was placed there during your investigation. The accusation of evidence planting should have prompted internal concern and careful documentation to protect both the officers and the integrity of any criminal case. Instead, Stevens seemed to view it as additional evidence of Javon's guilt and defiance. So now you're accusing police officers of planting evidence. That's a pretty serious charge, Mr. Washington. Are you sure you want to go down that road? Javon's response was measured but firm. I'm stating facts about what I know to be true. That substance was not in my vehicle when I began driving tonight, and I had no knowledge of its presence until you opened my trunk. Murphy photographed the discovered substance with his phone camera, while Stevens began the process of arrest, reading Miranda rights in a tone that suggested satisfaction with the evening's work. The entire scenario had unfolded with a precision that suggested careful planning rather than spontaneous law enforcement activity. As the handcuffs clicked into place behind Javon's back, he continued to assert his innocence while cooperating fully with the arrest procedures. His legal training reminded him that anything he said could be used against him, but he also knew that his silence might be interpreted as guilt by observers or future juries. I want to clearly state that I'm innocent of any drug-related charges and that I believe this arrest is retaliation for my civil rights work in the community, Javon said as he was placed in the back of the patrol car. The statement was calculated to create a record of his position and to establish the context that might explain why he had been targeted for this treatment. If his suspicions were correct, the arrest was not random law enforcement activity but rather a systematic attempt to discredit his legal advocacy on behalf of the East Richmond community. As the patrol car pulled away from the scene, Javon's vehicle was impounded as evidence, and the substance found in his trunk was logged into the police department's evidence system. The wheels of the criminal justice system began turning with the mechanical precision that had processed thousands of similar cases over the years. But this case was different in ways that the arresting officers couldn't have anticipated. They had targeted someone who not only understood the legal system intimately, but also possessed the knowledge and resources necessary to expose their misconduct and challenge their narrative in ways that most defendants could never attempt. The ride to the Richmond City Jail gave Javon time to think through the legal implications of what had occurred and to begin planning the defense strategy that would not only vindicate him personally, but also expose the systematic corruption that had made his arrest possible. What Officer Stevens and Officer Murphy didn't realize was that they had just arrested one of the most knowledgeable criminal defense attorneys in Virginia, someone who understood evidence law, police procedure, and constitutional protections better than many judges. Their carefully planned frame-up was about to encounter legal expertise that would unravel every aspect of their fabricated case. The booking process at the Richmond City Jail was routine and impersonal, designed to process defendants efficiently rather than to evaluate the legitimacy of the charges brought against them. Javon was fingerprinted, photographed, and assigned a booking number that would follow him through the criminal justice system until his case was resolved. During the booking process, Javon exercised his right to remain silent while observing everything that occurred around him. His legal training had taught him that booking procedures often contained irregularities that could be used to challenge the validity of arrests, and he wanted to ensure that no detail was missed. The charges filed against him were serious: possession with intent to distribute narcotics, a felony that carried potential prison time and would destroy his legal career if he were convicted. The arrest report filed by Officers Stevens and Murphy painted him as a suspicious individual who had been acting nervously during a routine traffic stop and who had been found with illegal drugs after a lawful search of his vehicle. Reading the police report, Javon was struck by both its internal inconsistencies and its careful construction to justify the search that had led to the discovery of the planted evidence. The officers had crafted a narrative that would be difficult to challenge without independent corroboration of the actual events, but Javon possessed something that most defendants lacked: comprehensive knowledge of criminal procedure, evidence law, and the constitutional protections that limited police conduct. More importantly, he had been recording the encounter from the beginning and had witnesses in the form of security cameras that had captured at least portions of the traffic stop. As he sat in the holding cell waiting for his arraignment, Javon began mentally constructing the defense strategy that would not only prove his innocence, but also expose the misconduct that had led to his arrest. The case would require careful coordination of constitutional challenges, evidence suppression motions, and civil rights claims that would address both his individual situation and the broader pattern of retaliation against community advocates. The fight was just beginning, and Javon Washington was about to demonstrate exactly what happened when institutional corruption encountered someone with both the knowledge and the courage to challenge it systematically and relentlessly. The morning of Javon Washington's arraignment arrived with the peculiar mixture of autumn sunlight and institutional fluorescence that characterized courtroom 4B. Judge Robert Whitmore settled into his chair with the confidence of someone who had presided over thousands of similar proceedings, expecting another routine morning of processing minor criminals and dispensing swift justice. The docket showed a straightforward drug possession case: an 18-year-old defendant charged with intent to distribute narcotics, represented by himself rather than counsel. To Judge Whitmore, it appeared to be exactly the kind of case that reinforced his beliefs about young people who thought they were smarter than the system that would ultimately hold them accountable. Javon entered the courtroom wearing the same pressed shirt and slacks he had worn during previous court appearances, his professional attire contrasting sharply with the typical appearance of defendants facing drug charges. Several spectators noticed his composed demeanor and quiet confidence, characteristics that seemed unusual for someone facing serious felony charges. Prosecutor Helen Fisher reviewed her file as court was called to session, noting the straightforward nature of the case based on the police reports provided by the arresting officers. The evidence seemed clear: drugs found during a lawful search, cooperative officers, and a defendant with no credible explanation for the contraband discovered in his vehicle. What neither the judge nor the prosecutor realized was that they were about to encounter a defendant unlike any they had faced before. Javon Washington wasn't just another young man caught with drugs. He was a licensed attorney who understood every aspect of the legal system that was now being used against him. Judge Whitmore called the case with his usual mixture of authority and skepticism, expecting to dispatch the matter quickly before moving on to more significant business. His initial comments about self-representation and the defendant's background revealed assumptions that would soon prove embarrassingly inaccurate. "Mr. Washington," Judge Whitmore began with condescending authority, "these are serious charges that could result in significant prison time and permanent damage to your future prospects. Are you certain you want to represent yourself rather than accepting the services of a qualified public defender?" Javon's response was measured and professional, delivered with the same calm confidence he had displayed during his previous court appearances as a practicing attorney. "Your Honor, I am confident in my ability to represent myself in this matter. I have carefully considered the charges and believe I can provide adequate legal counsel for my defense." The judge's eyebrows rose in apparent amusement, setting the stage for the confrontation that would soon expose his prejudices and assumptions. His subsequent comments about Javon's background and capabilities revealed biases that went far beyond normal judicial skepticism about self-representation. "Adequately prepared," Judge Whitmore repeated mockingly. "This isn't a high school debate club, young man. This is a court of law, where real consequences await those who don't understand the gravity of their situation. The charges against you carry mandatory minimum sentences that could send you to prison for years." Javon absorbed the judge's condescension without visible reaction, his legal training having prepared him for exactly this kind of institutional bias. He knew that Judge Whitmore's assumptions about his capabilities were based on stereotypes rather than evidence, and he was prepared to demonstrate the difference between appearance and reality. "I understand the serious nature of these charges, Your Honor," Javon replied evenly. "I'm prepared to address them within the proper legal framework and to present evidence that will demonstrate my innocence." Judge Whitmore's smile widened as he prepared to deliver what he clearly viewed as a lesson to an overconfident young defendant. His subsequent comments revealed the depth of his misconceptions about the person standing before him. "The proper legal framework," the judge echoed sarcastically. "How impressive. Tell me, Mr. Washington, where exactly did you learn about constitutional law and criminal procedure? From television shows and internet articles?" The question was designed to humiliate and diminish, to reduce Javon to a stereotype that would be easier to dismiss and sentence harshly. Judge Whitmore had no idea that he was addressing someone whose knowledge of constitutional law exceeded that of most practicing attorneys and many sitting judges. Javon's response came with quiet precision that should have warned Judge Whitmore that his assumptions were dangerously inaccurate. "Your Honor, I learned constitutional law and criminal procedure through comprehensive study of relevant statutes, case law, and legal precedents. I believe every defendant has the right to competent representation, whether provided by counsel or through self-advocacy." The answer should have prompted Judge Whitmore to inquire more carefully about Javon's background and qualifications. Instead, it seemed to fuel his determination to demonstrate his authority over what he viewed as an arrogant young defendant who needed to be taught respect for the judicial system. "Comprehensive study," Judge Whitmore repeated with obvious skepticism. "And I suppose this comprehensive study included analysis of evidence law, criminal procedure, and the rules of evidence that govern criminal trials in Virginia?" The judge's question was intended as a trap, designed to expose the limitations of Javon's legal knowledge and to justify the harsh treatment he was preparing to impose. What Judge Whitmore didn't realize was that he had just asked about subjects that Javon understood better than many attorneys with decades of experience. "Yes, Your Honor," Javon replied simply. "I'm familiar with the Virginia rules of evidence, the criminal procedure statutes, and the constitutional protections that govern criminal prosecutions in this jurisdiction." The confidence in Javon's voice should have given Judge Whitmore pause, but instead it seemed to increase his determination to demonstrate who controlled the courtroom. His subsequent questions became increasingly hostile and condescending, revealing biases that would soon be exposed in ways he couldn't have anticipated. "Mr. Washington," Judge Whitmore continued, his voice rising with authority and irritation, "do you have any idea how many young men I've seen come through this courtroom thinking they could outsmart the system? Do you understand that your attitude is only going to make things worse when it comes time for sentencing?" The threat was barely veiled, suggesting that Javon's legal knowledge and professional demeanor were being interpreted as disrespect that would be punished during sentencing. Judge Whitmore was revealing exactly the kind of bias that would ultimately destroy his credibility when Javon's true qualifications were exposed. Prosecutor Fisher began to show signs of discomfort with the judge's obvious hostility toward the defendant. While she was prepared to argue the state's case vigorously, Judge Whitmore's behavior was creating an atmosphere that could compromise the integrity of the proceedings and potentially provide grounds for appeal. "Your Honor," Fisher interjected carefully, "perhaps we should proceed with the arraignment and allow Mr. Washington to enter his plea to the charges." Judge Whitmore waved off the prosecutor's suggestion, his attention remaining fixed on what he viewed as an educational opportunity for an overconfident defendant. "In a moment, Counselor Fisher. I want to make sure Mr. Washington fully understands what he's facing before we proceed." The stage was now set for the revelation that would transform the morning's routine proceedings into something unprecedented in the courthouse's history. Judge Whitmore's assumptions and prejudices had been fully displayed, creating a record of judicial bias that would soon be contrasted with the reality of Javon's actual qualifications and capabilities. What happened next would shock everyone present and establish legal precedents that would resonate far beyond the confines of courtroom 4B. Javon Washington was about to reveal exactly who he was and what he was capable of, transforming Judge Whitmore's moment of judicial arrogance into a lesson about the dangers of assumption and prejudice in the administration of justice. The revelation began quietly, with Javon reaching into his briefcase to retrieve documents that would fundamentally change everyone's understanding of the proceedings. As he organized his materials with the methodical precision of someone accustomed to complex litigation, Judge Whitmore continued his condescending commentary. "Mr. Washington, I notice you've brought quite a collection of papers with you. I hope you don't expect this court to be impressed by whatever research you've printed from the internet." Javon looked up from his documents, his expression calm, but focused in a way that should have warned Judge Whitmore that something significant was about to occur. When he spoke, his voice carried the quiet authority of someone who was about to demonstrate exactly why assumptions could be dangerous. "Your Honor, I've prepared several motions that I believe are relevant to these proceedings. Before we address the charges themselves, I'd like to present evidence that will demonstrate fundamental flaws in the prosecution's case and misconduct by the arresting officers." The statement was delivered with professional precision that contrasted sharply with Judge Whitmore's expectations about self-represented defendants. Javon's terminology, his organizational approach, and his strategic thinking all suggested legal sophistication that seemed impossible given his apparent age and background. Judge Whitmore's expression shifted from condescension to confusion as he processed what he was hearing. The young man standing before him was speaking like an experienced attorney, using proper legal terminology and demonstrating familiarity with criminal procedure that exceeded what most defendants could achieve, even with professional representation. "Motions?" Judge Whitmore repeated, his voice betraying his surprise. "What kind of motions are you prepared to present, Mr. Washington?" Javon's response would begin the process of revealing his true identity and qualifications, setting in motion events that would expose Judge Whitmore's prejudices while demonstrating the extraordinary capabilities of the young man he had been systematically underestimating. The moment of truth had arrived, and courtroom 4B was about to witness something that would be remembered and discussed for years to come. "Your Honor," Javon began, his voice carrying the measured authority that had characterized his previous courtroom appearances as a practicing attorney, "I'm prepared to present 3 motions that I believe will fundamentally alter the course of these proceedings." Judge Whitmore stared down from the bench, his expression revealing the cognitive dissonance between his expectations and the reality unfolding before him. The young man he had been mocking and condescending to was speaking with the precision and confidence of a seasoned litigator. Javon placed the first document on the defense table with deliberate ceremony. "First, I move to suppress all evidence obtained during the traffic stop and subsequent search of my vehicle, based on Fourth Amendment violations and the systematic misconduct of the arresting officers." The motion to suppress was accompanied by a legal brief that would have impressed law school professors and appellate court judges. Javon had crafted arguments that combined constitutional analysis with detailed factual allegations, supported by case law and statutory authority that demonstrated comprehensive understanding of criminal procedure. "Second," Javon continued, "I move to dismiss all charges based on prosecutorial misconduct and the presentation of fabricated evidence. The substance allegedly found in my vehicle was planted by Officers Stevens and Murphy as part of a systematic effort to retaliate against my civil rights advocacy." Judge Whitmore's face had begun to flush as he processed the sophisticated legal arguments being presented by someone he had dismissed as an ignorant teenager. The motions were professionally crafted and legally sound, demonstrating knowledge that exceeded what most criminal defendants could achieve even with experienced counsel. Prosecutor Fisher leaned forward in her chair, reviewing the documents that Javon was presenting with growing alarm. The legal arguments were compelling and well-researched, raising serious questions about the integrity of the case she had assumed would be straightforward to prosecute. "Third," Javon announced, his voice rising slightly for emphasis, "I move for sanctions against the arresting officers and a federal civil rights investigation into the systematic harassment of community advocates in East Richmond." The third motion was accompanied by documentation that had revealed the broader context of Javon's arrest, including evidence of retaliation against residents involved in the civil rights lawsuit and patterns of misconduct that extended far beyond his individual case. Judge Whitmore struggled to maintain his composure as the implications of what he was witnessing began to sink in. The young man he had been treating with condescension and barely concealed contempt was demonstrating legal knowledge and advocacy skills that rivaled those of the most experienced attorneys who appeared in his courtroom. "Mr. Washington," Judge Whitmore said finally, his voice betraying his confusion and growing concern, "these are quite sophisticated legal arguments. How exactly did you acquire the knowledge necessary to prepare such comprehensive motions?" The question opened the door for the revelation that would transform the morning's proceedings from routine criminal arraignment into legal history. Javon straightened slightly, his posture reflecting the dignity and professional bearing that had been evident throughout his legal career. "Your Honor, I am a licensed attorney in the Commonwealth of Virginia, admitted to practice by the Virginia State Bar after successfully completing the bar examination. My bar number is 47291, and I have been practicing law for approximately 18 months. The statement hit the courtroom like a thunderbolt, creating complete silence as everyone present processed the magnitude of what they had just heard. Judge Whitmore sat frozen in his chair, his mouth slightly open as he grappled with the reality that he had been systematically mocking and condescending to a colleague in the legal profession. Court reporter Shanice Jenkins stopped typing mid-sentence, her hands suspended over the stenotype machine as she processed the unprecedented situation unfolding before her. Bailiff Jerome Thompson straightened in his chair, his expression reflecting amazement at the revelation that was reshaping everyone's understanding of the proceedings. Prosecutor Fisher felt her face drain of color as she realized the implications of what Javon had just revealed. She had been preparing to prosecute a case against a licensed attorney, someone who understood the legal system better than most defendants, and who possessed the knowledge necessary to expose any irregularities in the prosecution's case. Judge Whitmore's mind raced as he tried to reconcile his assumptions and prejudices with the reality of Javon's professional credentials. Every condescending comment he had made, every assumption about Javon's capabilities, every display of judicial bias had been recorded and witnessed by a courtroom full of observers. "You're claiming to be a licensed attorney?" Judge Whitmore asked, his voice betraying both disbelief and growing panic as he realized the magnitude of his error. Javon reached into his briefcase and withdrew his Virginia State Bar admission certificate, along with documentation of his active status and good standing with the Bar Association. He approached the bench with professional courtesy, offering the documents for judicial review. "I'm not claiming anything, Your Honor. I am a licensed attorney, and I have the documentation to prove it. I passed the Virginia Bar examination 18 months ago and have been practicing law continuously since my admission." Judge Whitmore examined the documents with trembling hands, his face growing increasingly pale as he verified the authenticity of Javon's credentials. The bar admission certificate was genuine, signed by the Chief Justice of the Virginia Supreme Court, and bearing all the official seals that confirmed Javon's professional status. The courtroom remained frozen in stunned silence as the implications of the revelation continued to sink in. Spectators who had witnessed Judge Whitmore's condescending treatment of Javon now understood that they had observed judicial bias directed toward a member of the legal profession. "Your Honor," Javon continued with quiet dignity, "I believe the record will reflect that I have been subjected to inappropriate judicial commentary based on assumptions about my age, race, and background, rather than my actual qualifications and professional standing." The statement was delivered without malice or accusation, but it carried devastating implications for Judge Whitmore's conduct during the proceedings. Every comment he had made about Javon's capabilities had been preserved in the court record and witnessed by numerous observers. Prosecutor Fisher rose from her chair, her voice shaking slightly as she addressed the court. "Your Honor, in light of this revelation, I believe the prosecution needs time to review our case and consider the allegations that have been presented." The prosecutor's request reflected her growing realization that the case she had expected to be straightforward was now fraught with complications that could destroy not only the prosecution but also the careers of everyone involved in fabricating evidence against a licensed attorney. Judge Whitmore attempted to regain his composure, but his efforts only highlighted the magnitude of his error. "Mr. Washington, Attorney Washington, I apologize for any misunderstanding about your qualifications. However, that doesn't change the fact that you're facing serious criminal charges." Javon's response demonstrated both professional courtesy and unwavering determination to expose the truth about his arrest and the systematic misconduct that had led to the fabricated charges against him. "Your Honor, I accept your apology, but I believe this court needs to address the substantial evidence of police misconduct and prosecutorial irregularities that have been presented. The charges against me are not just unfounded, they are the product of criminal conduct by law enforcement officers who planted evidence in retaliation for my civil rights advocacy. The allegations were serious enough to potentially trigger federal investigations and criminal prosecutions of the officers involved." Judge Whitmore realized that his courtroom had become the scene of revelations that would resonate far beyond the immediate proceedings. As the morning progressed, Javon systematically presented evidence that dismantled the prosecution's case, while exposing the broader pattern of misconduct that had led to his arrest. His legal arguments were sophisticated and comprehensive, drawing upon constitutional law, criminal procedure, and civil rights statutes with the expertise of someone who understood the legal system intimately. The audio recording of the traffic stop, captured on Javon's phone, revealed the systematic nature of the officers' misconduct and their coordination in planting evidence. Security camera footage from the convenience store corroborated Javon's version of events and contradicted key elements of the police report. Most damaging to the prosecution's case was evidence that officers Stevens and Murphy had specifically targeted Javon because of his role in the civil rights lawsuit against Richmond Development Corporation. Their arrest report contained internal inconsistencies that suggested coordination and fabrication rather than legitimate law enforcement activity. By noon, the prosecution's case had collapsed entirely, and Judge Whitmore was forced to dismiss all charges against Javon Washington. But the implications of the morning's revelations extended far beyond the individual criminal case. Federal authorities would ultimately investigate the systematic misconduct exposed by Javon's arrest, leading to criminal prosecutions of the officers involved and broader reforms within the Richmond Police Department. Judge Whitmore would face judicial conduct investigations that would effectively end his career on the bench. Most importantly, Javon Washington's extraordinary journey from community advocate to licensed attorney to vindicated defendant would inspire legal reforms and educational initiatives that would benefit countless individuals who faced similar challenges within the criminal justice system. As Javon packed his briefcase and prepared to leave courtroom 4B, he reflected on the morning's events with the quiet satisfaction of someone who had demonstrated that truth and competence could ultimately prevail over prejudice and misconduct. The young man who had entered the courtroom facing serious felony charges walked out as a vindicated attorney whose courage and expertise had exposed systematic corruption while reaffirming the principles of justice and equal treatment under law. The explosive truth had been revealed, justice had been served, and the legal system had been reminded that competence and character could not be determined by age, race, or appearance, but only through demonstrated ability and unwavering commitment to truth. Judge Robert Whitmore's assumptions had been shattered, the prosecution's fabricated case had been destroyed, and Javon Washington had proven once again that exceptional talent combined with moral courage could overcome even the most entrenched prejudices and institutional barriers. The story would be remembered and retold for years to come, serving as both an inspiration for young advocates and a warning for those who would judge others based on stereotypes rather than evidence. In the end, truth had prevailed. Justice had been served, and the legal system had been strengthened by the courage of one remarkable young attorney who refused to be diminished by the prejudices of those who should have known better.